The moment a cop says, "I need you to blow into this device or you'll lose your license," most drivers panic and comply. And here's what happens. You blow, the number comes back 0.08 or higher, and you've just handed them the strongest evidence they need to convict you. I've analyzed over 300 DUI stop body cam videos showing this exact scenario. I've identified the pattern officers use to pressure you into giving up your strongest defense. I'm going to show you the tactical distinction between two different breath tests, the counter move that protects your position, and exactly what to say when cops deploy this threat. Here's the real situation. There are two completely different breath tests. The first is the roadside handheld device called a PAS or PBT. This is voluntary in most states. You can refuse it with zero penalties. The second test happens at the police station on a larger machine. That's the evidentiary breath test, where implied consent kicks in. Officers blur these two tests together, saying, "I need you to take a breath test," without specifying which one. If you think they're both mandatory, you've already lost. If you know the roadside test is voluntary, you control the first battleground. Now here's the trap. Implied consent laws exist in every state except Wyoming. When you got your driver's license, you consented to chemical testing after arrest. But implied consent only applies to the station test after arrest, not the roadside screening. Officers say, "You have to take this test or you'll lose your license for a year." That's true for the station test, but they often say it at the roadside where refusal carries no penalty. This is the coercion tactic. Your tactical response depends on knowing which test you're facing. Let's break down your tactical response for the roadside test. Officer says, "I need you to blow into this device." Your counter move is, "Officer, is this the preliminary roadside screening or the evidentiary test?" Now watch what happens. This question forces them to clarify. If it's the roadside PAS test, you say, "I respectfully decline the preliminary screening." Deliver it calm, clear, and firm. Say it again. "I respectfully decline the preliminary screening." Here's what the live exchange looks like. Officer, "Sir, I'm asking you to take a breath test." You, "Officer, is this the preliminary roadside screening or the evidentiary test?" Officer, "It's a breath test to determine your level." You, "I understand, officer. I respectfully decline the preliminary screening." Officer, "Refusing makes you look guilty." You, "I understand your perspective, but I'm exercising my right to decline." This works tactically because you're not giving them the probable cause boost they need. Without that PAS reading, they have to rely on field sobriety tests and observations, which are far more subjective and easier to challenge in court. The PS device result can be used to justify arrest even if you're under the limit. Here's the escalation path if you don't counter. You blow into the device. It shows 0.05, which is under the legal limit, but the officer now has quantifiable evidence you've been drinking. That reading, combined with any other observations, gives them probable cause to arrest you anyway. Now they take you to the station for the evidentiary test. That one comes back 0.08. You're done, so lock this in. I respectfully decline the preliminary screening. Practice that response right now. If they pressure you with, "It'll be easier if you cooperate," your response is, "I understand, officer, but I'm exercising my right to decline." The mistake most people make is thinking cooperation means giving them evidence. Cooperation is being polite and respectful. Evidence is tactical suicide. Remember, the roadside test is voluntary in most states. Now here's the station test scenario. You've been arrested. You're at the police station. They present the implied consent warning, stating that if you refuse the breath or blood test, your license gets suspended for 6 months to a year depending on your state. This is where the tactical calculus changes. You have two options. Option 1, take the test and risk providing the 0.08 or higher reading that makes conviction almost certain. Option 2, refuse the test, accept the administrative license suspension, but force the prosecution to prove impairment without a BAC number. Here's the tactical reality. In many cases, the license suspension for refusal is shorter than the suspension for a DUI conviction. Plus, without a breath test, the prosecutor builds their case on officer observations, field test performance, and your statements. That's a weaker case and easier to challenge in court. Let me show you the tactical comparison. Wrong move. You panic. You think, maybe I'm under the limit. You blow. The machine says 0.09. The prosecutor now has an airtight case. Your counter move at the station. I want to speak with an attorney before I make this decision. Say it clearly. I want to speak with an attorney before I make this decision. In most states, you have the right to contact a lawyer before deciding. Use that right. Here's what officers are trained to tell you that's completely legal deception. They can say, "We have witnesses who saw you swerving," when they don't. They can claim, "This will go easier if you cooperate," knowing cooperation means conviction. They can tell you refusing the test means automatic arrest when you're already under arrest. They can say, "Everyone who refuses fails anyway," to pressure you into compliance. Officers can legally lie about evidence, consequences, and what's in your best interest. The one exception, they can't fabricate official documents or test results. So when they say, "Just take the test and we'll see what happens," what they really mean is, "Give us the evidence we need to convict you." Your tactical shield against this deception is simple. Anything an officer tells you during a DUI stop should be viewed as a tactic to get evidence, not advice in your interest. That's why your countermove is always attorney first, answers never. Tactics vary by state. In some states, like California and Maryland, marijuana odor alone no longer justifies a search or extended detention. In Texas and Ohio, odor is still their green light for searches. For breathalyzer refusal penalties, they range from 6-month suspension in Massachusetts to 18 months in Florida for a second refusal. Some states, like New York, add fines on top of the suspension. A few states have criminal penalties for refusal. Here's your tactical baseline regardless of state. The moment you're facing the station test decision, you say, "I want to speak with an attorney." That statement stops the clock in many jurisdictions and gets you legal guidance before you make a decision that could cost you your license, your freedom, or both. While you're waiting, if they continue questioning, your response is, "I'm invoking my right to remain silent." Then actually remain silent. If you end up taking the test under their order, state clearly for the recording, "I'm complying under your order. For everyone's safety, I'm recording this interaction as well." That creates a record that your compliance wasn't voluntary. Here's the field rule that wins every time. At the roadside, you can refuse the preliminary screening with 0 penalty in most states. At the station after arrest, you have the right to an attorney before deciding. The tactical principle is simple. Never give evidence voluntarily, and always make them work for every single piece they get. Now lock in these 4 counter moves. 1. Am I free to leave? 2. I'm invoking my right to remain silent. 3. I want to speak with an attorney. 4. I do not consent to searches. Right now, practice saying these out loud 3 times each. Say them until they feel completely natural. The moment you hesitate or fumble is the moment you lose tactical advantage. Stay calm, stay tactical, stay in complete control. Be polite, not talkative. Your composure is your tactical advantage. This is tactical education only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. If you found this valuable, hit that like button, subscribe to the channel, and turn on notification bell so you never miss a tactical breakdown. Control the interaction, control the outcome.